Good afternoon on the e-platform of Faculty of Law, GLS University. It is an auspicious day, and as it is truly said, Shubham Karoti Kalyanam, Arogyam Dhan Sampada, Shatru Buddhi Vinashaya, Deepa Jyoti Namastute. With that shloka, with that chant, we are starting our today's most awaited session. As truly said, that Swasti Prajapaya Paripalanate, Nyayena Margena Mahi Mahisha, Go Brahmanebhya Shubhamastu, Nityam Loka Samasta, Sukhino Bhavantu. Let law prevail and make everybody happy in the world. With that note, I would like to request Dr. Sudhir Nanavatiji, our President of GLS University, for welcome address. Over to you, sir. Dr.
Thank
Sudhir
you,
Nanavatiji.
Payal. Thank you, Payal. Good evening to all, and good morning to Harish J, since he is in London. Today we have between us Mr. Harish Salve. It is hard to introduce him as he is a household name today, not only because he is a great lawyer, but all for his contribution to the development of law and a unique example of a senior lawyer of Supreme Court of India becoming the Queen's Counsel. A man synonym with justice and law, I hold Mr. Salve with utter admiration and affection, and hence I would like to introduce Padma Bhushan Sri Harish Salveji in an informal way. And indeed, Mr. Salve, I thank you for joining us for this e-talk. Presence today truly shines like a diamond. I would specifically like to mention this that Mr. Salve is someone who I have worked very closely with, and we have crossed paths many a time due to our common area of work. But it amazes me every time of how can a man with such a high stature and a global reputation be so humble. Sir, on behalf of GLS University, a GLS Law College, and myself, I humbly welcome you and convey my gratitude for accepting the invitation for the talk. Today's subject, the shuttle art of advocacy, prospective challenges of legal profession, which itself is such an important topic that your guidance on the basis of your experiences in this profession will help the law students who are participants of this e-talk. Mr. Salve, the youngest Solicitor General of India, has represented almost all the top industrial houses of the country that you have heard of. But as they say, it is not what he is or even what he does which expresses the worth of a great man, but what he is. It is always the duty of every lawyer that when his professional services are required for some important subjects touching the country or the public at large, he should always be ready and willing to provide the same. Mr. Salve is the live example when he had accepted the brief of Mr. Kulbhushan Jadhav, a prisoner in Pakistan jail, when he not only argued the matter on behalf of the country in the international court, but he also carried a point which is accepted by the International Court of Law. The another important side of Mr. Salve in his humbleness in accepting rupee 1 only as his professional charges, which itself speaks volumes about Mr. Salve, that even after reaching the pinnacle of success, he is always ready and willing to protect the interests of the nation. I fondly recall the times when I visited a office, and whenever I did so, Mr. Salve, apart from being an illustrious lawyer, is also an excellent host. He knows that I am a foodie just like him and insists that I have at least something before I leave from there. I've indeed never seen such a successful person as grounded as him. There have been numerous instances when I have not been prepared for a matter, but Mr. Salve, the observant expert that he is, would know the details of the case minutely, and I am in awe of how exceptionally sharp and utterly dedicated a person can be. Mr. Salve has a wonderful capacity of articulation. His arguments are so engaging and interesting that even a common man can follow what he is saying. There is a saying which goes like this: to acquire knowledge, one must study, but to acquire wisdom, one must observe and dedicate his life to it. And that is how I think men like Sri Harish Salve are made, with sheer intellect, passion, keen observation, and dedication. His knowledge in the field of law is unmatched. Being both a CA and a lawyer has an additional advantage of understanding law from various perspectives, and I believe there is no area of law that is not ventured into. Like I said before, Mr. Salve and I have had a long working and a personal relationship, and each time I meet him, I get learn something new from him. Such a gem of a person he is. In all courts, I have seen judges conduct with utmost respect towards him, and if he makes a statement on any matter or topic, it is to be known that there is a certainly truth in it to the best of his knowledge. Students, I know you all want to be like him and even work with him in your career of law. But to reach the height at what he is today, you need to develop not just in law, but also ethics, attributes, principles, and value system from him. And also have the same passion for law and order in your, and that is why grab this best opportunity that you have today to learn from the man himself. Not taking much of your time, as I'm sure you are eager to listen to him, I would just like to say that just like it would take another thousands of years for the world to give us another M.K. Gandhi, it would be the same another years to give us another Harish Salve, because as they truly say, great men are born great, they grow great with gut and grime of the world. Thank you and have a great day.
Thank you so much for such a warm welcome, sir. We are thankful, as sir has already introduced our great guest of today, Harish Salve, sir, and with a very good metaphor sir has used, as he mentioned M.K. Gandhi, sir. None other, just as we already know that Padma Bhushan, Salve, sir, his practices encompasses public international law, human rights, civil fraud, public energy, and tax. He is also admitted to the bar in England and Wales and was also appointed a Queen's Counsel in the year 2020. Salve sir was a former Solicitor General of India and is senior advocate at the Indian Bar, practicing largely in the Supreme Court of India. In the year 2015, he was awarded with one of the India's highest accolades, that is Padma Bhushan, and Sir has handled many renowned cases at International Court of Justice like the Jadhav case, Republic of Marshall Islands, TMA Pi case, Environment Police Reform Matter, Upar Matter, and many more. He has a world-class commercial law practice, and his expertise in the courts of both England and Wales as well as India gives him unrivaled experience as lead counsel representing multinational corporations in multi-judicial litigations. Padma Bhushan, Mr. Harish Salve, has appeared for Reliance Industries Limited, Vodafone PLC, Vedanta Resources Limited, and many more. The most important thing is, Sir is very fond of Sir is very fond of piano playing. Sir is an excellent and passionate piano player. And sir, we are all, your words would be music to our ears, and we are all ears to hear it from you. Without taking much time, we request today's chief guest and our Honorable Mr. Harish Salve, sir, to deliver his speech on very apt subject, the subtle art of advocacy, prospective challenges of legal profession. Over to you, sir.
Thank you. My dear friend Sudhir, Dr. Nanavati, as he is known to all of you, Dr. Mehta, Dr. Pandya, other organizers, and young friends from the bar. It's always a great pleasure and delight to share ideas with younger members of the bar. I feel energized, I feel reinvigorated every time I interact with youngsters. I feel that they have brought new energy to our profession. I see them coming in at an age which is marked by what we call disruption. Disruption today is not a pejorative phrase anymore. It, in fact, describes the finest tradition of replacing the old with the new which is more contemporary, the new which is more relevant, and the new which is more necessary for delivering societal needs. All areas of life, government and non-government. In the non-government, the exercise of professions as well as the doing of business. Everything has seen disruption. Everything has seen change. Everything has evolved. And our profession has not been passed by these tsunami of change. Advocacy has come a long way from, as we say, from the days of Siqueiro to what we are heading towards, the days of Mr. Robo, an artificial intelligence, who will be doing part of the advocacy very soon. Advocacy of the 50s, advocacy of the 60s, advocacy of the 70s was very, very different. And it was different because the dynamic of litigation was different. Somewhere along the way, the legal profession became vested. The legal profession became static. And that is where we lost connect with the needs of society. And that's not India. That's a global phenomenon. It's the famous American who had written that article saying litigation reminds you of that nice slow dance where people continue, where the lawyers continue waltzing with each other to their own delight. And the clients are merely the orchestra who provide the music. There is a joke in England about a young member of the bar joining his father's firm as a solicitor. And his father goes for 1 month's leave and he comes back and his son tells him, I have done a lot of good work, Dad. I have cleaned up a lot of pending cases. And he looks at his son and says, you're an idiot. I had kept those going for decades. So this is where somewhere along the way, we lost touch with what we really need to be. And where is this reflected? This is reflected in the massive increase in caseload, in the massive pendencies, and in lawyers losing their stature in society. Ultimately, we are service providers and we will be respected as long as we continue to service society's needs. The caseload crisis has hit every system, not just India, but its magnitude is dramatically different in different countries. The American legal system complains of 2 years for disposal of a case. Here in London, in our commercial courts, we are very proud of the justice delivery system. In fact, UK has perhaps the highest degree of what is called legal tourism. People agree to have English law governing their contracts so that the dispute resolution comes into English courts. And the strength, the USP of English courts was effective justice delivery. Today, it takes 2 years for a case to be disposed of, and those 2 years are considered a horrifically long period here. Unfortunately, in India, a case disposed of in 2 years is considered fast track. So there is a caseload problem everywhere. But more than the number of cases being filed, we have to acknowledge as lawyers, it is our practices which have not evolved with time. And those practices have led to these crises today, where the citizenry is losing its faith in the judicial system. What we need today, going ahead, is rethinking the role of the lawyer and the role of the courts. When we talk of advocacy, we must recognize, for clarity, its different silos. You have the criminal justice system, which works in its own way. You have the civil justice system, which works in family law and other areas in one way. And now you have the burgeoning commercial dispute resolution system. Commercial dispute resolution system includes bipartisan disputes between parties. It includes disputes between regulators and parties, disputes affecting commerce and commercial entities. What then is the adaptation which our profession sorely needs to bring in order to be the disruptors of 2021? The 90s saw the introduction of technology in our work. Like most other people, but particularly so in our profession, there are some of us who looked happily towards technology to try and move ahead. And there are some of us who set their back against technology, saying, we can't do this. Look at how we have worked our systems. The introduction of computers has taken, it's a sorry story, in a country like India, where the world respects India as the forerunner in digitalization. They respect Indians as being extremely, extremely adept at working computers, at coding, at developing software, at developing programs. Our legal system struggles even in 2021 to computerize its basic functions, where other countries are moving ahead. China, to an extent, has brought artificial intelligence into dealing with cases involving small crime, petty crime. That's how far our neighboring country has gone. And here you find, even now in Supreme Court, those dirty old files being circulated. Now you see judges getting more and more accepting of the change in the systems, more accepting of computerization. Why does it help you? Why is it so necessary? These are not newfangled ideas. We have to remember today, society is far more advanced than the society our grandfathers used to live in and our fathers used to live in. Gone are the days where the lawyer was considered as a man of great learning and man entitled to great respect, and nobody questions his ways. Today, society measures you by the worth and value of the service you provide. And this is going to be more and more sharpened as time goes by. What does society measure you by? Society measures you by your talent, but it measures you by also the cost efficiency and the time efficiency. Results, of course, have to be provided, but they have to be provided in a way which is cost efficient and which is time efficient. If we have to be service providers today, successful service providers, to meet these requirements of cost and time efficiency, what are the adaptations we need to make to advocacy? Let's look at our criminal justice system. It is, I don't know whether it is even accurate to describe it as teetering on the brink of collapse. People even now languish in jails when a part of their term of the conviction, or a substantial part of term of the conviction, sentence, they spend in jail even before they hit trial. Why? This backlog. Yes, we have a shortage of judges, and that's a discussion for another day. But with our existing system, are we willing for change? I think we need to do what the UK did 25 years ago when Lord Wolfe's committee sat on the civil side and came up with a report. We need to make the system more user-friendly. The Code of Civil Procedure needs to be rewritten. It has to be made simple. It has to be made effective. A litigant should be able to understand what's going on. And that is the important change of the 21st century. The increasingly literate client, the increasingly aware client in this world of social media, in this world of internet explosion, people can Google and find out what is going on and what should be. That far better informed client is not happy with the way we deliver service. What should we do? We have to find ways of making our service more cost effective. Court management. Court management is very important. Look at the psychological and emotional cost to a client of an adjournment. In this country, I practice now in both jurisdictions. In this country, an adjournment is unheard of. Either the case settles or you drop dead, or the case goes on the date fixed, unless something dramatically wrong happens. If they ever have to adjourn a hearing, you will get 4 emails from the judge's secretary apologizing and offering you another date. And 1 or 2 occasions when this has happened are flagged up by journals, by newspapers, saying that the system is collapsing. Why? Because the case got adjourned. Are we willing to bring in that culture into India? We must. It's not only lawyers' fault. Why do cases get adjourned? Because judges don't fix dates. Because judges don't stay with their dates. Why? Because case management is not considered important. The one important change which has come into advocacy is case management. Civil cases, criminal cases, right at the beginning, the judge and the lawyers have to sit down together and work out how they are going to manage a case. And once the steps of the case are frozen, the timelines are frozen, you have to stick to it. That is what inspires confidence in the litigant. So one new practice which we have to bring in is case management. That is how we will convince society that we are not making a fool of our consumers. Otherwise, you ask a consumer and he says, I don't know what's going on. I don't know when my next date is. And even if it comes, I don't know whether the case will go on the next date. If the people lose faith in the system, ultimately our practice will perish. And we also have to realize this is a matter of self-preservation. A much bigger, in fact, a sea change has to come in the way we practice commercial law. When I say when we practice commercial law, I divide it into two parts. The private element of commercial law and the public element of commercial law. Public element of commercial law is tax disputes, regulatory disputes like competition, monopoly, telecom, airports, now real estate, and so on and so on. The need for a far more transparent manner of conducting litigation is the need of the hour. Today, it's a matter of great pride that India is becoming the favored destination for foreign investors. It's a matter of great pride that today people say that with China slowing down and for various other geopolitical reasons, India is going to be the hub of all investments. I was speaking to a very, very senior Indian businessman, and he said there was a time that we had to go and raise capital. He says, today I have a time where international funds call me and say, we have so much money to invest, and I have to tell them, thank you very much, but no thank you. I don't have anywhere to put your money. Can we capitalize on this disruption? Now, why we as lawyers? Where do we fit in this equation? We have a very important role to play in this equation. If you look at the ease of doing business, one of the things always held against India is dispute resolution machineries do not exist. Now, let me explain to you what that means. If a commercial dispute is going to take 10 years, 5 years, 7 years, for all practical purposes, that is hopeless. No corporate investment, no business investment has this generous laggard timeline of 4 years, 5 years, 7 years for resolving a dispute. We have to have effective, again, a cost-efficient and a highly time-efficient dispute resolution system. We have to change our practices. What is it that I have learned living in this country for the last few years, increasingly working in this country? What I have learned is A, take on only as much work as you can handle. B, the devil lies in the detail. I had the privilege of, and that is a timeless secret. I had the privilege of working with Mr. Palkhiwala way back in 1978, 79, 80. And Mr. Palkhiwala, I noticed, had two very important attributes. First of all, there was never a question the answer to which he did not know. That was his level of preparation when he came to argue a case. The second, he would try and make the most complex point seem as simple as can be. The subtle art of advocacy is not making a simple point sound like a thesis, not make a simple point, not make a legal issue sound such that only those few exponents of the law who are well versed in it understand it. The subtle art of advocacy is making the most complex point seem so simple that the judge feels, but of course he's right. When you put it very simply, There is a great attractiveness to what you are saying. I can say without fear of contradiction, the sentences which Mr. Palkhiwala spoke, if you put them down on paper, you could not reduce even one word. They were that concise. Brevity, preparation, brevity, and clarity of thought. These are the attributes of the law of 2021. Without this, we will never achieve efficiency in time or in costs. The devil lies in the detail. You have to be the master of your case. Only then can you focus on what is relevant, focus on that which needs to be projected and the order of importance in which you need to project that for your client's case to be explained to the presiding officer. These have to be coupled, and that's another growing attribute all over here. It's been there in this country for a while. When they separated the commercial courts, they separated the chancery courts, then there is a construction court, domain expertise. In fact, when I had suggested to the government they set up commercial courts, I'd gone thus far and say, you can provide an extra allowance for judges who are either management graduates, chartered accountants, or engineers, because they are better educated to deal with certain disputes. A judge hearing a complex dispute about construction of property or delays in construction or those kind of disputes would be far better equipped to come to terms, to cut through the morass of facts, to, as they say, separate the grain from the chaff, if he is a domain expert. Look at the increasing flood of litigation coming from the Securities Appellate Tribunal and the financial markets. Unless you know what are the practices of the financial market, how do you learn? Look at the disputes coming from the competition law. We have, and I am very impressed, we have bright youngsters who work on this. You have to have domain knowledge of economics, you have to have domain knowledge of competition practices all over the world, and so on. And that is when you bring all that to bear, then you don't discover your way as you go along in a case. You know exactly what to say, you know what not to say, you know what to focus on. And that also achieves cost efficiencies. It achieves time efficiencies. This is the new mantra. And on all this, there is the overlay of technology. How can we best use technology to reduce time, to increase the efficiency of dispute resolution? We need to improve efficiencies in dispute resolution. And it can be done. Things put on from the very basics now, where records are on a cloud, they are readily accessible, they are cross-referenced. One of the practices which we follow now, and I have been trying to persuade the government of India to loosen its purse strings and to persuade judges to bring that in, is live transcription. It saves so much time. And today, I'm in the middle of an arbitration with a 2-week break, where there is a record of 10,000 pages. And all you need to do when you're arguing, when you're cross-examining a witness, is give the reference of a document and it shows up on the screen. So you don't go running from one bundle to a second file, to a third file, to a fourth file. This is where technology increases time efficiency. And time efficiency improves the overall quality of the product we are giving. The product being efficient dispute resolution. The post-COVID world looks very different. The post-COVID world forced us out of our comfort zones and forced us to resort to practices. The virtual platforms. We now do international arbitrations using virtual platforms. Nobody has to travel. The costs are so much more efficient. You don't have to waste time recovering from jet lags, or even in a country like as diverse as India. If Sudhir can sit in Gujarat and do a case in Delhi in the Supreme Court for a client from Gujarat, see the cost efficiency, see the time efficiency, and why not? I must say, I have seen something very interesting when I have been watching the going ons in the Supreme Court. We all grew up, I grew up in the Supreme Court from 1978, and for every one big case for which there would be a big lawyer, high fees charging lawyer briefed, there would be 5 cases of middle class people coming from all over India, small value disputes. And that small value dispute did not justify the client bringing his local senior lawyer from his domestic, from his regional place. So a lawyer from Guntur, a lawyer from Raipur, a lawyer from Bhubaneswar would feel odd coming especially to Supreme Court. So we had a large body of advocates on record in Supreme Court. We had various tiers of senior counsel in Supreme Court, those who do small cases with lesser fees, those who would charge bigger fees and do bigger cases, and so on. What I have seen in COVID times is, in one sense, it has become a very inclusive court. Now I see a lot of regional lawyers sitting in their cities and arguing cases for their regional clients. And believe me, the local lawyer who has conducted the case in the court of first instance, in the first appeal court, and maybe even in the high court, knows that case backwards. He is much quicker, he is much more to the point, and he manages to get that case done much faster and much better many times than maybe a counterpart in Delhi who has to start reinventing the wheel and acquainting himself from the case from scratch. So it has been, yes, I know a lot of lawyers have lost their livelihood because the throughput of work got seriously reduced. But then this has been a disruption in the model in which the Supreme Court works. Look at the United States. There is no such thing like the bar of the US Supreme Court. The bar of the US Supreme Court is the top lawyers of US. Of course, in England, there is no such thing like the bar of the UK Supreme Court. All the top lawyers of United Kingdom appear in the Supreme Court. So this has been one disruption which I have seen in the last 3 years. Now, how this is finally going to play out is a matter to be seen. But these important changes, and finally, we have for years delayed computerization because we feared computerization. We were not willing to learn new skills. Please understand, a doctor has to learn latest medicine. A surgeon has to learn how to use the latest equipment. We as lawyers owe it to our clients to be able to use technology wherever we can, to minimize costs, to increase efficiency. Artificial intelligence is around the corner. We must show the same degree of acceptance towards artificial intelligence and use it wherever we can, where we find that artificial intelligence reduces costs, increases efficiency. Yes, I know what I'm saying sounds as though a lot of lawyers may lose work. And it is unfortunate that these things happen when disruption happens. But let us also remember one thing. We lawyers ultimately are officers of the court, and we lawyers are service providers. It is our duty to service the rule of law. And if rule of law is not marked by easy access to justice, the rule of law itself is threatened. Access to justice, again, has two elements: the costs of access to justice and the efficiencies in access to justice. It's a discussion for a separate day that our budgets for government funding of litigation are abysmally low. We need to invest a lot more money. In this country, for example, the fees charged even by the legal aid lawyers is very high because the government pays. It's not that you get a pittance for doing legal aid work. So legal aid work is not charity. Legal aid work is a reasonably remunerated profession. But that's a discussion for another day. As lawyers, we must remember, we carry a very heavy burden. And that burden is that we have to make access to justice a living reality. And if we fail to do that, society will lose faith in us. Society will lose faith in rule of law, as we see increasingly signs of people losing patience with our system. And ultimately, as a profession, we can only survive if there is a vibrant democracy, if there are courts, if there is a justice delivery system, and most of all, there are clients who have faith in this system and are willing to use it. Thank you.
Thank you so much, sir, for your nice address and shedding light over a very apt topic that says the subtle art of advocacy and prospective challenges of legal profession. So there are so many questions during your address were popping up. With your permission, would like to go for the open floor.
Oh,
If you
absolutely.
can. Sure. So the first question is from our uh, student Samarth Bhatt. He is just asking that you had been an advocate in Kulbhushan Jadhav's case, and what were the challenges that you had been through as an advocate during that particular case? Can you just name few, please?
If I may say in a lighter vein, the biggest challenge was keeping those 11 judges awake when giving my address. Let me tell you why. The International Court of Justice, it was a tremendous experience for me. The International Court of Justice is a court, but is also a court with very diplomatic practices. Because ultimately, it's a court where only sovereign nations are litigant parties. So your advocacy has to adapt to the language used in diplomacy. The second important thing is that it's a mix between written and oral advocacy. A lot of work is done through memorials, and it's a completely different, albeit a fascinating branch of the law, public international law. The third challenge is you're given 90 minutes, for example, or 60 minutes. I was given 90 minutes for my principal speech. And because there are multilingual judges, a template of what you are going to say orally has to be given to them no later than 7 a.m. in the morning. So I was sitting till 3 in the morning, fine tuning, reducing commas, reducing full stops, reducing alphabets, trying to shrink everything into 90 minutes, and then practicing its reading. And in my transcript, I had written down, at this point, I should be 20 minutes down. At this point, I should be 45 minutes down. And sometimes you have to compress it because if you're reading slow or if you're reading this. So it was a very, very different experience from what you have. But most of all, what's fascinating was if you study public international law, it's a great growing jurisprudence. And as a lawyer, my biggest satisfaction came where I managed to persuade even the majority to read in the International Covenant on Civil and Political Rights into diplomatic relations.
Great, sir. Thank you so much for sharing your experience. The next question is from a very young student of semester 1, Tirth Shah. He wants to ask that compared to other developing countries, India has a robust judicial system. Judiciary is fairly independent in our country. Despite this, the conviction rate is very low and the criminal justice system is not up to the mark or up to the expectation. What are the drawbacks in our system according to you? Can you recommend measures for an effective criminal justice system?
Straight away, there's been a lot of discussion. Then what we need to fix our criminal justice system, and I say so openly, is political will. Nowhere is the investigation as enmeshed with local policing as it is in India. Committee after committee has said you need a specialized criminal prosecution system. Even in Vinit Narayan, Supreme Court said you must have a director of prosecution. The prosecution has to be segregated from your law and order police. Your law and order police must work under the political system. Whether or not to stop a morcha, whether or not to stop a protest, is a decision the politician has to take. How to investigate a crime has to be done by an officer who must have no interface with any politician or any civil servant. So first of all, we have to have a separate investigation system. Then they must be trained in the finest skills of forensic science in today's world, use technology for forensic investigation. Once you achieve these two and you have a good level of investigation, comes the third level, computerization of criminal courts. They should have everything available on the click of a button. The entire record on the click of a button. Digitalized, all interrogation done on video cameras, on videotapes, so that nobody can complain that he was forced to make a statement, etc., etc. Use technology for all this. And examination of witnesses, you don't have to wait for a witness to come from another village. Today, just send a van to his house with a VC and have him on VC. And use technology to speed up trials so that this adjournment culture goes away. These 4 or 5 measures will go a long way. But most of all, we have to have a superior quality of investigation. And we have to have all the aids of technology today available to the smallest judge, the junior most judge, so that we can speed up this most important branch of the law. The most important, the average Indian's interface with the law comes in the magistrate's court. And that is the most important branch of the law.
Thank you, sir. Next question is very apt, which says that in India we follow an adversarial legal system in which the court is the referee between the prosecution and the defense. And contradictorily, in Western countries, they follow an inquisitorial system in which the court is involved in investigating the facts of the cases. Demand for the inquisitorial system is now emerging in India, very slowly, but yes, it does. What are your opinions? Should India adopt inquisitorial system?
I'm not particularly sure that there's anything wrong with our system or that the inquisitorial system is more result oriented. In the Western world, it's only in the civil law countries, as you call them. In Europe, that you have the inquisitorial system where there is a magistrate who investigates, a judge who investigates, but then that judge doesn't conduct the trial. So ultimately, when it gets into a trial, it does become a adversarial system. What is inquisitorial is at a lower level that the judge takes a lot of decisions. In one sense, we do have an inquisitorial system. We have stopped working it. The magistrate is supposed to oversee an investigation. Whenever there is a hiccup, the magistrate can order fresh investigation. He can look at the investigation. He can steer the investigation. That poor magistrate is so busy morning to night hearing bail applications that he doesn't have time to read, because under the Code of Criminal Procedure, regular reports have to be filed by the police of the state of an Indian investigation. If we free up our magistracy, we do have a quasi-inquisitorial system in place. But what have we replaced it with? We have replaced it with a very, very dangerous new trend. And I don't mince my words when I say this. You then have the Supreme Court taking upon itself to get into an inquisitorial mode. And we have seen 3 very bad results of this. You have seen it in the Jain Hawala case. You have seen it in the 2G case and in all the other related cases. Whenever the Supreme Court gets into inquisitorial mode, that I think is the biggest danger and the biggest threat to the rule of law. And I don't mince my words when I say that. It's these quick fixes are no use. We have to restore our magistracy to the role which the law has reserved for them.
Thank you, sir. That was a question from third semester students, our second year student. This is the question from third year student who is saying that India has a bitter experience on retrospective taxation. India is losing the tax disputes. For example, the Vodafone case, sir, is well versed about that. What will be your opinion on retrospective taxation and how are other countries dealing with such disputes?
There are 2 layers to this. One is, of course, you see, it's not retrospective taxation per se. Sometimes you come up with a law, you make a mistake, within 3 months you correct it with retrospective effect, or in 6 months you correct it. Or like the example they gave of Britain, they came up with a measure. They realized that it was being abused. The finance minister told the banks, if you don't stop these kind of schemes, I will discontinue this benefit. The banks did not listen. In the next year, he said, I had warned you 3 months into the law, don't do this. You've done it, I'm changing the law. So that is not really retrospective taxation. Those are corrective measures. Retrospective taxation is a retrospective change in policy. And what we need is 2 major changes in India. And this is a mindset change. The first is, borrowing a phrase that Mr. Palkhiwala used to always use, all wisdom does not reside in the North Block. Tax measures must be debated in society. Your budget, I'm not talking of the tax rates, which you need to keep secret to prevent speculation. If there is a measure of taxation, take what have we done in Vodafone? We have introduced measures of what is called OIT, overseas indirect taxation. The world has been worried about overseas indirect taxation, about layering of companies in which the resource country doesn't get its fair share of tax. There is a whole project being run by the Organization of Economic Cooperation and Development, the OECD. It's called the BEPS project, Base Erosion and Profit Sharing project, where different countries are putting their heads together on how to deal with a country not getting its fair share of tax, in which norms have emerged of what is called OITs, overseas indirect taxation. It was a major policy change. Why could we not have debated it in public life? But we believe all wisdom resides in North Block, and if they decided to tax something and it didn't work, arrogance of power, we can do it. Our parliament is sovereign. Arrogance of power, we do it, which is the second lesson we need to learn. We are not an insular country anymore. You're part of a global economic village, and your word matters. People should be able to trust you. The world runs on trust and faith. A retrospective measure is a breach of trust.
There is a question from semester 7 student that arbitration and competition law are regarded as opposite poles of the magnet. How do you see the future of arbitrability of competition law, especially in India?
I wish someday our society matures enough that regulators and business people can sit across the table and resolve disputes without the regulator worrying about a CVC, CIT, CBI, FBI, and somebody filing a petition for SIT, BIT, FIT inquiries. People should be able to walk. Here, what happens? You walk into the HMRC office and you say, this is my business structure. And they say, this is acceptable, this is not acceptable. You discuss, you arrive, your structure is accepted, your future taxation is sealed. If you have a competition law dispute, the first thing they want you is come talk to us. And then if you can't arrive at a via media solution, then you litigate. So arbitration, in fact, I would say mediation of competition disputes. It's done everywhere. In America, what happens? First thing is the Justice Department calls you and says, stop this practice. And you say, okay, can I do it this way? Or can I do it that way? And then they work it out. And it's all a process which is done here. Let me give you the English example. Vodafone also invest in Europe through subsidiaries set up in Luxembourg. HMRC issued a notice to them saying, we want to tax this because we think unfairly Britain is being denied its share of tax on your profits. They took it to the European Commission, saying that this is an impediment on free trade in Europe. The European Commission said, no, nobody has prevented you from setting up a company in Luxembourg, but it is for the English tax authorities to see whether it's a genuine company or whether it's a measure of tax avoidance, in which case the local laws must govern. So what did Vodafone do? They sat with the HMRC officials and the Chancellor. They arrived at a figure of 300 million or 400 or $2 billion or something. They paid the tax, inquiries over. And somebody asked, there are people like that here also. Somebody asked saying, oh, you've done a sweetheart deal with Vodafone, you 2 billion tax. He says, yes. We sat with them 2 billion and we thought that was in taxpayers' interest. Next question, please. That's how it works. In India, you would have had an SIT, you would have had the finance minister should be investigated. Somebody would have filed a petition in court, and then Supreme Court would have said, set up so and then give us periodic reports and investigate. People say, hell with you, go fight in court and get it decided. Why should we decide? So, this mindset change has to come in India.
Thank you, sir. Our very young first-year student wants to ask that in 2013, you were admitted to English bar, and that time you were already a strong leading person in India. So how the transformation from being in Indian courts to England court to English court went for you? It is, if you could
it's
share
work
your
in
personal
progress.
experience.
Life is always work in progress. As a lawyer, we are always students. As a lawyer, we are always learning. So it's been a wonderful, there are so many practices which one learns here, which I think make you a better lawyer. The attention to detail, the time you spend, the thoughts you have to break, the intense attention to giving time to thinking new solutions. So that's the culture of this part of the world. And I think that's something which all of us could learn and do well. I sometimes say, some of us had got into, and if you, I say this of my colleagues in Supreme Court openly, some of us had gotten to legal retailing. Instead of taking on big cases, taking your time over them, studying them and helping develop the law. So it's been, in that direction, it's been a wonderful change. And as I said, it's work in progress.
Okay, sir, in your opinion, what steps are required from the government side and from judicial system to improve justice delivery and minimize the time to deliver the justice?
3 things. From the government, I would say overnight treble judge salaries. Today, please see the figures. The low judge-citizen ratio is not only because we do not have enough posts, we don't have enough posts filled. You have today jobs in direct recruitment of subordinate judges going a begging. Way back, when Justice Lauti was not even Chief Justice, so I must have been Solicitor General 13 years ago, when they were hearing a PIL on the Consumer Forum. Justice Lauti called me and he says, I've called you solicitor for only one thing. I want to ask you, do you know what salary is paid to the member of a member of the district forum? I said, no, man. He said, 5,000 rupees. I said, what? He said, Mr. Salve, how much do you pay your driver? I said, no, definitely more than that. And he says, 5,000 rupees, no perks. Now, are we serious? So, what I'm saying is we need a thorough overhaul of judges' salaries. Look at other parts of the world. Lawyers always make more money than judges. So nobody is saying pay a judge equal to the highest paid lawyer, but at least pay a judge enough so that he can live a good upper middle class life. So one is from the government side, increase the salaries, increase the availability of technology to judges, fund it generously. From the judicial system side, once please embrace technology and please be more robust as judges. Throw out the bad cases quickly. Don't postpone the evil day. Weed out your cases. And most of us, from us lawyers, the present ecosystem must change. We have to bring disruption into our profession. This luxurious style of practice, or we take a date and then we don't show up on that date, and then the case gets adjourned, and then papers are never ready and things are not ready. And it happens to all of us. All of us are guilty of this. I'm not pointing fingers at anybody. This culture has to go. We have to become far more businesslike and cooperate with the judges, because if we don't cooperate with the judges can do nothing. Cooperate with the judges to make our system effective and to make access to justice a living reality.
Thank you, sir. We know that we are having short time. If you permit, we'll just ask last question for today, considering the time limit. Do you allow, sir?
Yes, please.
Sure. Globally, the legal profession has undergone substantial changes as a result of the economic crisis and the evolution of the legal industries and market. Now the country is empowered to set the terms and conditions in the procurement of legal services. What will be your guidance to our budding lawyers to meet the global challenges of this legal profession?
Sorry, I lost you for a second in the end.
Sure, sir. I'll repeat that. Now the country is empowered to set the terms and conditions in the procurement of legal services. What will be your guidance to our budding lawyers who are just listening to you, sir, to meet the global challenges of legal profession?
First of all, don't fear international practices, embrace them. If increasingly we are becoming a global village, and if increasingly foreign investment is coming into India, and we all want to benefit out of foreign investment coming into India, we must also be there in a position to provide service of the kind of service they are used to. Otherwise, they will get their service from outside. So don't fear it, embrace it. There is a whole new world of technology and of practices. The law colleges today, especially our national law schools, provide the kind of education which at least my generation did not have access to. We are today, and I am so proud of this, when I see youngsters, some of the Indian youngsters today, I am so proud that they are already at a level of knowledge of law which perhaps in our generation, a lawyer of 5-7 years at the bar would not have. And I love to see their focus, their dedication, and their spirit. Harness this spirit. The most important thing is this spirit of Indians, this hungry Indian kid who wants to move ahead in life. Embrace the world. Don't fear the world. Embrace the world. There are lovely practices all across the world. Adapt them to India, adapt them to your work, and you will see how you will grow as a person, how your work will grow, and how you will be an important cog in the wheel of justice.
Thank you so much, sir, for enlightening all our viewers with all your answers. Now, I would like to request the Wind Beneath Faculty of Law, GLS University, Dr. Mayuri Pandya, to offer vote of thanks to our esteemed guest. Over to you, ma'am.
Thank you, Payal. I extend my earnest gratitude to our honorable speaker of today's e-talk, Padma Bhushan, Mr. Harish Salve, sir. Sir, thank you so much for accepting our invitation and sparing your valuable time. And what you said, the take home for the students, especially no adjournments, the case management, and there is a need for the rethinking of the role of the lawyers. And I do feel that whatever advice you have given today, that all my budding lawyers will take, and that will be a change definitely in upcoming years. Once again, thank you so much, sir. And with that, one request also, which one should not do while vote of thanks. But sir, we look forward you on our campus someday at your convenience. Once again, thank you so much. I also extend my thanks to Sudhir sir, President GLS University, for always an inspiration for us to arrange all these activities. I also thank entire Gujarat Law Society family and all the members of GLS University. Thank you all my students and everyone who has joined today, all the viewers with us today. Thank you so much.
Thank you so much. Now I would like to request all the dignitaries to stand up, to rise at their place for national anthem. I request you to.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जन गण मन
Thank you, sir.